It's time for FLA Law, brought to you by the personal injury attorneys of Perenich, Caulfield, Avril Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are here live in the studio with FLA Law on the radio. My name is Jacqueline Bryant. I'm one of the attorneys at Perenich, Caulfield, Avril Noyes, and I am here in the studio with my partner, Matthew Noyes. Say hi, Matt.
Hello, hello.
And we are here with FLA Law live on the radio. As you know, we are here every Tuesday at 5 o'clock on your drive home to answer your legal questions live on the radio. So before we jump into our live legal call-in show tonight, of course, I'm going to give you all the info so you know how to call in and how to get your questions answered. We'd love to hear from you and answer any potential legal questions you might have. As you know, we are personal injury attorneys with the law firm of Perenich, Caulfield, Avril Noyes. You can find us at voiceoftheinjured.com. And so our conversation tonight is of course, going to be kind of tailored towards personal injury matters and those types of claims. But of course, we want you to call in with any legal questions you might have, and we'll take a stab at those tonight. So the call-in number is going to be 727-441-3000. Again, that's 727-441-3000. That's the number to call in if you want to have your question answered live over the air. You can talk to myself and Matt. But of course, if you are one that does not like to hear your voice on the radio, but you want to have your question asked anyway, we are streaming live from two places tonight. If you have a Facebook account, look us up on Facebook with Perenich, Caulfield, Avril Noyes Injury Lawyers. We are streaming live right now. We're in the studio. For those that are watching, it looks like we have one or two viewers. You can actually type your question in the comment section. I can see those live as they come in, and I will ask those questions out live over the air, and Matt and I will definitely take a stab at those questions as they come in. We had a couple good ones last week, so I'm hoping we get some more this week.
That'd be good.
And so we're also on YouTube. So if you don't have a Facebook account, but you want to leave a comment or a question, we're streaming on YouTube as well. Again, that's Perenich, Caulfield, Avril Noyes Injury Lawyers. Perenich is spelled Perenich. So those are all the ways that you can reach us tonight and get your questions answered over the air. And you'll have the pleasure of speaking to myself and my partner, who is a seasoned partner with the law firm, who's been with the firm, about
35 years.
35 years now.
Yes.
So you're in good hands with your questions tonight. And of course, it's been a pleasure that I've been able to work with him all 12 of my years in practice, as I've been with the firm my entire career as well. So Matthew Noyes, take it away if you'd like to introduce yourself again to our audience, who I'm sure knows you quite well.
Sure. Thank you, Jacqueline. I am Matthew Noyes. I'm one of the attorneys at Perenich, Caulfield, Avril Noyes. We do handle all kinds of cases involving personal injury, including car accidents, trip and falls, slip and falls. But also we handle work injuries like workers' compensation claims, and we also handle Social Security disability claims. We found out that many of our clients that get hurt in auto accidents need attorneys when they get hurt in other ways.
Absolutely.
And so that's why we started branching off and also doing workers' compensation.
Lots of overlap, exactly.
And Social Security disability.
Yep. I've talked with Lori and Brian about this as well. I think the last couple of shows that it's good to have a firm like ours that you can kind of keep all your cases under one roof when you have an attorney who's experienced in not only the personal injury side, but also can handle your Social Security claim and the workman's comp claim, which a lot of times all those tend to be intertwined.
Yeah, and if you're not careful, you can do something in the workers' comp case that hurts the auto case, or do something in the auto case that really jeopardizes the workers' comp case. And then when Social Security disability is thrown in, you can really impact the back benefits of Social Security disability if you don't cross your T's and dot your I's during the workers' comp part of the claim.
Exactly right. And so as we go throughout the show, as you know, if there's any questions you have for us, if you'd like us to review a case or something that you're dealing with in the personal injury, workers' comp, or Social Security realm, just remember that even after we're off the air, you can find us at voiceoftheinjured.com, and we'll, of course, give you all our office numbers at the end of the show. But, of course, I want to jump into our conversation tonight to kind of go over some what I call FAQs, or frequently asked questions, that we often get from clients or potential new clients when they come into our office. And a lot of it has to do with, just customer satisfaction and informing, your client on what's going on with the case and how what their expectations should be of the process. So I wanted to ask you some of these questions, Matt, so we, of course, can inform our listeners and our viewers about kind of what they should expect when they're kind of getting involved in hiring an attorney in this type of a case, right?
Sure, yeah. I mean, it's not an easy decision to make. And so they often do have lots of questions before they finally decide which attorney they're going to have.
Exactly. And we tend to hear some of the same ones over and over again. So I try to kind of highlight some of those tonight and see if we can touch on those.
Sure.
So when it comes to an auto claim, a lot of times people come to us and they really want to know, should I call the insurance company? I want to talk to you first. Should I report that myself? What is the typical, way to address that issue?
It is important. Well, after you're involved in an auto accident, it is important to talk to the insurance company. But when we say talk to the insurance company, we have to delineate which insurance company
which one we're talking about. Yeah.
I always recommend that you report your injury to your insurance company.
Exactly.
They do not have to start paying personal injury protection benefits until your injury has been reported to them. So yes, talk to your insurance company. When it comes to the at-fault driver's insurance company, or whether there's a dispute about fault, then I would not talk to the insurance company until you talk with an attorney.
Exactly.
Those adjusters are trained to ask you certain questions in a certain way to try to trap you into an answer that they're going to use against you later. And so it's just important, especially when there's a dispute about liability, that you talk to an attorney before you even talk to the insurance company. They're not your friends.
Exactly.
They're there to minimize the claim as best as they can.
And to get you to go away if they can. If they can rush you to a quick settlement, make a very, small offer, get you to sign off on paperwork that you're not really informed about without a lawyer, that can unfortunately be detrimental to your case. There's
insurance companies that drive all around town and adjusters with releases and checks are all ready to issue the check at the accident scene or the day of or the day after.
Right.
Just trying to get a release signed so then they can claim that the case is closed. And although you don't really appreciate the magnitude of your injuries from a crash, sorry, you signed a release and you're out of luck.
Right, and they won't inform you of that. They won't say, well, hey, if you get something new, just call me back and we'll reopen it and I'll take a look at those new bills. That's not the way it works.
Right. So. I had a case where a client got hurt, and not to get too into the law, but massage therapy is no longer affordable under the personal injury protection coverage. PIP doesn't have to pay for massage therapy.
Exactly.
And so the adjuster said, hey, I think you need to have some massage. So why don't I write you a check for $2,000 so you can have $2,000 worth of massage therapy and so you can get to feeling better.
Right.
Client thought that was good. She signed a piece of paper. Actually, she e-signed it because they wanted to do it by mail only.
Yeah.
And turns out that what she signed was a release of any and all claims, and it wasn't just a massage therapy.
Yeah, and those e-signs are even trickier.
It's convenient, but it's at risk.
It does.
I find myself guilty of it. You go to the next, and you go to the next, and you're not even reading what you're signing.
And so, I think that's exactly why it's designed that way. Unfortunately.
I think so too. Yes.
So. Another big question we get up front, I feel like it may be a little bit out of order, but I feel like it's one of the most prevalent and prominent questions I get is, how long is this going to take, Mr. Noyes? Is this something that I'm going to be able to resolve within a few months, or are we talking years? How long does a personal injury case generally take?
Typical attorney answer, it depends. That's for sure. It all depends on the magnitude of the injury. In the best case scenario, you get a few treatments with the doctor, and poof, you feel better, and you don't need to bring a claim. Not every auto accident results in the need for an attorney.
Right.
If personal injury protection coverage was provided, that if you have a flare up or a small duration of pain and you get the medical treatment to take care of that, then you don't need to make a claim against the at-fault driver.
Right.
But unfortunately, many times an auto accident results in a long-lasting injury.
Exactly.
It doesn't mean it doesn't mean it has to be a broken bone, or it doesn't have to be an arm being missed or anything like that, or even surgery.
Right.
But if your neck muscles or your back muscles are stretched to a point where scar tissue fills in the spaces where blood used to flow, you have restricted range of motion, you have pain, and that doesn't go away.
Exactly.
And so usually medical treatment has to go on for about 6 to 8 months worth of active medical treatment before they can determine whether or not there's a permanent injury.
Exactly.
Then once the permanent injury has been determined, then the settlement negotiations begin. And that could be 2, 3, 4 months of trying to get the insurance company to evaluate the claim appropriately. If the case can get resolved, great, the case is resolved. But if the insurance company relies on some computer program to say what the value of your case is, instead of listening to the impact that the crash has had on your life and on your family's life, well, then litigation may be needed.
Right.
And if litigation is needed, it goes on even further.
Much longer.
Usually about 18 months to 24 months before you even get to a jury trial.
Right.
Albeit most cases settle without a jury trial, but you got to prepare for it. You got to prepare as if you're going.
When you're getting into that case, you have to prepare as if you are certainly going to trial. And so I think building up the medical evidence and the proof of your case is so important, like you said. And so I always tell people in the very beginning, we are not going to rush that treatment process. We want you to see the doctors and get the opinions and the treatment that you need so that we are building up a strong case, because at the end of the day, it's not about you being in that crash that entitles you to damages. It's about you being injured in that crash. How do we prove you were injured? With the treatment, with the records, those are the things that you need to do. And so a lot of people, if you're like me, I'm guilty. I don't like to go to the doctor.
You and me both.
Yeah, I got to be pretty much dying, for me to go and get checked up. You don't want to be that way in a personal injury case, because you're only, unfortunately hurting your claim and probably causing it to be undervalued.
Right. And that being said, we never want our clients to treat just to treat.
Right.
There's no need to treat to build a case. Mm-hmm. The only reason why you want to treat is to document your injuries. Mm-hmm. If there are no injuries to document, then don't treat.
And you don't need a lawyer, quite frankly, if you're not hurt. Most of the claim, if it's your vehicle or things of that nature, or you've got maybe a time off from work, PIP, and those coverages can handle that really without the assistance of an attorney. Right. When you are injured, that's when you need to give us a call.
And it's hard to believe that two personal injury attorneys are telling our listeners that you may not need us. I don't think they see that on TV commercials from the other places.
And that's why you tune into FLE Live every Tuesday at 5.
That's right. Because
you're going to get the real deal.
That's right.
So with that being said, assume I am injured and I do need to treat, but I don't know where to go. As my attorney, can you refer me to a physician?
The answer is yes. We can always refer you to to a doctor. The problem is that juries and insurance companies have tried to paint the picture that, gosh, if the attorney referred you over to that doctor, they must be in cahoots and planning and building up a case that's not really there.
Right.
Well, that's hogwash. Right. Because really, if you needed a referral to a doctor, once you go and talk to somebody who knows doctors
Exactly.
and has interacted with doctors and knows which ones are the good doctors and which ones are
quality care.
care. And we know from our clients, some want a better bedside manner.
Yes, of course.
And they'll give, and you can have the best doctor in the world, but if they have bad bedside manner, that's not going to help that client.
Exactly.
So, yes, the attorney can certainly refer a doctor over to you to get treatment. It's always better to do your own research as well.
Right.
And once you do your research, then you can talk to the attorney about, okay, I've done this research. My sister said to go here. My neighbor said to go here. I looked up in Google, and the Google reviews to say go here. What is your recommendation, or what's your input?
Exactly.
And so it's just, we're just another source for them to select a doctor that can be best for them.
Exactly. And if you already have established relationships with primary care physicians or things of that nature, then it's always good to consult them as well. If you have a rapport with your own doctor, they are informed that you've been injured in a car accident. There's nothing that says that you shouldn't talk to them about this. You should. I think it's good to go see your primary care physician. Now, a lot of times they won't accept the auto PIP coverage, but they can still refer you to, reputable physicians in the area or near your home that are going to treat you for the car accident.
I am amazed at some of the family doctors or the general practitioners. As soon as you say car accident, Dr. So-and-so can't see you. It's like, I just want his input. He doesn't need to treat me.
I just want to tell me what I should do.
But no, it's like, it's a plague. You can't, you got in a car accident, your doctor who's been seeing you for years, and if not decades, all of a sudden isn't qualified to see you. It doesn't make sense.
Of course, that gets into insurances and all that, but
forms.
They don't know how to bill it.
Exactly.
So that's a great answer, Matt. And so, as you said, of course, if you do your own research, talk to family, friends, and try to find providers that can help. But of course, you can always consult with your attorney and confer with us to make sure you're making a good choice when it comes to your doctor.
Right. And I just don't think it's fair that the insurance companies can try to make it sound like that, just because the attorney made the referrals, that there's something wrong about that.
Exactly. And unfortunately, now that is the case as of March 24th of this year. It used to be off limits. That was attorney-client privilege. Whatever discussions you had with your attorney in regards to doctors or what have you was privileged, as I think it should still be.
Sure.
But unfortunately, now that's not the case when it comes to doctor referrals. That is something that they can discover and ask about. So
that's right.
Just something to be aware of when you're talking to your attorney about your doctors. So another question I get often, I'm sure you've heard many, many times, Matt, is missing time from work after a personal injury case, whether it be a slip and fall or auto accident, which are going to be treated a little differently. But they get hit, they get injured, and they're now out of work, and they need some money coming in now. Is there a way to do that in personal injury cases where they can kind of get interim payments throughout?
Well, if it's an auto case, yes. If it's an auto case and you get hurt, if you get hurt in the accident that keeps you out of work and you have a doctor taking you out of work, then personal injury protection coverage will pay a portion of that lost wages while you're out of work. But just a portion. It pays 60% of your lost wages.
And that's coming from your own auto policy.
And that's coming in addition to the 80% of medical that's being incurred. So
exactly.
With the 60% of lost wages and the 80% of medical, that $10,000 can be gone pretty quickly.
Very quickly.
Yeah.
Especially if you went to the emergency room, you were driven there by an ambulance. Those PIP benefits do not go very far.
Right. So yes, there is a way to get lost wages in an auto accident, but it's for a limited period of time as well.
Right.
Short-term disability, of course, if the doctor has you out of work and you have a short-term disability policy with your employer, you can certainly file a claim with there. The only thing is, short-term disability will knock on the door and say, please pay us back.
They have a right of reimbursement.
And it's a right at 100%. If it's an ERISA, not to get too technical, but if it's an ERISA.
Through your employer.
If it's through your employer, then even though you had to hire an attorney to fight to get the wages, and you're not getting 100% of your lost wages because you have to pay the attorney.
Mm-hmm.
Short-term disability or any ERISA plan say, well, that's okay. We still want 100. We want 100% of what we paid.
Right, which is interesting when they did nothing to help you procure the money to get it back. But
right, and then workers' comp too. If you're hurt at work,
exactly,
and you have the workers' comp doctor having you out of work, then you would be entitled to temporary partial disability benefits if they say light duty,
mm-hmm.
or you'd be entitled to temporary total disability benefits if the workers' comp authorized doctor says that you can't go back to work at any job at that time.
Right. So unfortunately, when it's a situation like a slip and fall or trip and fall, or the auto PIP benefits have now run out and you are still out of work, it's a situation where we're now making that claim as a part of the demand package or settlement negotiations towards the end. So there's no checks that are going to be coming in weekly or biweekly, sadly, during that process, because the defendant's coverage does not make payments for wage loss as the time is being accrued, unfortunately.
Right. They don't pay for the damages as they happen.
Mm-hmm.
Now that runs a risk though. And I know we probably didn't talk about this, but that runs the risk of those TV commercials of cash advances and you're not working, call us now,
right,
and we'll give you a loan. What are your thoughts about that?
Oh gosh, well, I hope they're not out there listening. I typically do not recommend those loans to my clients, only because, at the end of the day, the interest rates are very high, and they can unfortunately end up taking a good chunk of the overall net to the client at the end of the case. And I kind of use them at your own risk. If at some point, you're facing an eviction or you can't feed yourself, then those options are available. And if you can't get it from any other source, if you can't borrow it from a family member or some other thing, and that's the only option you have, then they may be, what you have to do. And we, of course, will be obligated to repay those loans out of any recovery that we get. But I try to make that a last resort if possible.
I agree with you. I mean, if you can put it on a credit, if you can borrow off of a credit card, that interest rate's going to be cheaper than
much less. Yeah.
And it does impact, as you were saying, it impacts the net recovery. I mean, if you borrowed $1,000, and this isn't exact science or math, but if you borrowed $1,000 and it took 2 years to get a settlement, you could be paying $3,500 back for that $1,000. Well, that's two things. It impacts your decision making.
It does,
because it's like, well, gosh, I can't pay $3,500. I mean, my net recovery after I pay the $3,500 is not going to be what I want it to be.
Exactly.
So that's a problem. But I also think it's a problem if juries get to understand that a cash advance was done.
Right.
I think juries would say, gosh, you've already betted on me.
You've already gotten your money.
Yeah. And you think that I'm going to award you money? You've already betted. Yeah. So so I agree with you 100% that, we discourage them as much as we can. I always say desperate people have to do desperate things in desperate situations from time to time. And that's once you've exhausted every other way, I never let my clients just sign without me reading them the little lecture. So my staff knows that if there's an application or a client's talking about a cash advance, they know to set up a phone conference or an office conference.
Exactly right.
To hear the lecture from me.
I do the same thing. Yeah. And so at the end of the day, that kind of segues into my next question. So when you're talking about loans and you're thinking about the case value and what do I have to pay back at the end, those loans are going to be piled in and evaluated, but not by the insurance company. Insurance company doesn't care about the loans.
Not a bit.
They're looking at your medical bills, your lost wages, and things of that nature. So as the client, sometimes they ask, should I be getting my own medical records? Should I be tracking those bills, requesting copies of those things, or do you handle that? How does that work?
Well, we always like to request the medical records and the medical billing as it comes in. And we try to keep track of that as well. We also request the PIP payout sheet, which is really just an explanation of what the insurance company paid after an auto accident case.
Right.
But ultimately, it's the client's responsibility to know what they're being charged.
Yes.
We give them updates, but we don't always have all the billing all the time.
Exactly.
So it is important for the clients to have an understanding that it's not an unwritten check or what is that called? A check, an open check, a blank check, a blank check just to keep treating and treating and treating. There are many times when it's like, okay, especially if policy limits are limited.
I was just about to say there could be coverage limits that are very low that you want to be aware of.
So it won't do any good to have a $10,000 auto insurance policy limit and have $8,000 in outstanding medical bills.
Exactly.
It just, the math won't work.
Exactly.
My sister's a math teacher, but even she couldn't figure out that problem, I don't think.
Oh, great. So I think that brings us to our caller. We have a caller on the line. It looks like it's Max from Clearwater on line 1. Hi, Max. Can you hear us?
I can. How are you guys doing?
I'm good. How are you?
Good evening, Max.
I'm doing well. So my question is, when I was on my lunch break today, I was reading the news, and I read that in Louisiana, there's this crazy, 100-car, pile-up collision because of fog. Now, I know the laws are a little different in Louisiana, but if that kind of situation were to happen in Florida, would they have to figure out who initially caused, those 100 cars to crash, and then everyone would have to go after that insurance? Or would it be based on, the chain reaction domino effect? You go after the insurance of the person behind you that hit you, that kind of thing.
Max, you must have been in my brain because I was thinking the same thing.
I didn't hear about that
this morning. No, it was dense fog, and so it was fog and the smoke from the wildfires.
Oh, really? Huh?
There was 100, at least 100 cars, right, Max? Isn't that what you remember?
Yeah, 100 plus or something like that.
Oh, wow.
Cars were knocked off the interstate, so it was devastating.
Gosh.
But Max, you raise a good question.
Mm-hmm.
Who's responsible for that? Yeah, and every state is different, and Louisiana is probably the most different than any other one because they do common law. I think that's what it is from back in my law school days. But a French law or something like that.
I have no idea. I know their statute's the same as ours now. We're both 2 years.
Oh, okay. But yeah, the question then, you have to establish fault.
Right.
And if the car behind you that ultimately smashes into you was stopped, then they weren't negligent. So who was it? Was it the car behind them, or was it the car behind them, behind them, behind them, behind them? And so it is a snowball effect of trying to find responsibility.
Set off the chain reaction, yeah.
And then there's going to be limited coverage. If one car caused 10 people to get into a collision, that cars only their coverage is only limited to their bodily injury liability coverage.
Right. And so now you've potentially got hundreds of people trying to divide a small policy. And in a state like Florida, I'm not sure what Louisiana's law is, but we are now a modified comparative state. And so it could be a situation where everyone's a bit at fault.
Right.
And so now they may have no claim if they're found to be 51% at fault, and everybody can be effectively barred from making claims at all.
Right. So I think that's why uninsured motorist coverage would be so important.
It is. It is very important. I don't know if you're still on the line, Max, but did that answer your question?
It did. Thank you very much.
Thanks so much for your call. Looks like we also have a call or a question in the chat. Let's see here if I can move that. The lines are open. That frees up our line. So if you want to call in and have another question, feel free to ask. We've got a question on Facebook that says, how long does it take to get your personal injury claim taken care of? So that kind of falls into what we were talking about before, where, as Matt said, it's really driven by your treatment course and how long you need to treat. Sometimes the injury that you sustained takes quite a while to resolve, or for the doctor to kind of go through the necessary course of treatment with you, depending on the scar tissue and the range of motion and the therapy. And sometimes you try therapy. and then you try injections, and then you need a surgery, and then you have to recover from the surgery. So that process can take a while. So the timeline of your case is really driven by your treatment. And then ultimately, after that treatment is completed, it's driven by, can we resolve it or are we litigating it?
It's if the insurance companies want to behave or not behave.
Exactly right.
But that does raise a good question about treatment after a car accident. You need to treat after a car accident within 14 days of the crash.
Oh, yes. We did touch on that for sure.
If you don't treat...
So I feel like people had it for a while and people are starting to forget that those benefits can be lost.
I know. So. I mean, when it first changed, before it was okay, as long as you saw a doctor within a reasonable period of time and the doctor felt that it was reasonable, necessary, and related to the crash.
Right.
Well, then the doctor could submit the bill to your insurance company for the benefits that you paid for all those years. All of a sudden, the law changed and said, no, now you have to see a doctor within 14 days of the accident, and the doctor has to say that it's reasonable, necessary, and related to the crash. But if you wait 14 plus 1 day, then they don't have to pay for those personal injury protection benefits, even though you paid premiums for those.
You paid for that, right?
For those benefits.
Which is horrible.
Yeah.
So before we take a quick break and go to a commercial, I want to ask you one last question and see if we can get this answered for our listeners. Before our break, how often should I expect to hear from my attorney during a personal injury case?
That's a good question.
Yeah, because we often get people who call from other firms and they're not happy because they haven't heard from their lawyer. They don't know what's going on. So what should you expect in a personal injury case?
The biggest bar complaint is not hearing from the attorney. And that haunts that I
things
should say
that keep you up at night.
Yeah, I should say that haunts my legal assistants because I keep reminding them, it's so important that we keep touch with the client.
Yes.
I mean, the attorney needs to touch base with the client whenever something happens in the case that moves the case forward. And in the beginning of the case, while you're treating, it may not be a lot.
Right.
It may be, okay, I got these records. It looks like you're about to reach maximum medical improvement. We're about to do the settlement demand and such. Once it gets into settlement negotiations, you're probably going to hear from the attorney a lot more.
Exactly.
And then once it goes into litigation, you're going to hear from the attorney when events happen. But it's funny, in litigation, it seems like there's a lot of stuff that's going on behind the scenes without the client being involved. But, I mean, our policy at our office is that, the client receives an update at least every other month.
Right.
But always, 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 if you ever have a need to talk to your attorney, you're paying them eventually. But you're paying them. And you should always be comfortable to say, I want an office conference or I want a phone conference, whatever it may be, to get an update. Absolutely. And the attorney should be willing to do that.
Absolutely. And that's exactly what I tell my clients. At the end of the day, you only have one attorney. Now, I may have many, many clients, but you only have one attorney. So I understand you want to hear from your attorney. You want to know what's going on. Call me.
Right.
Just call me.
We won't know that you have questions unless you call us. Unless
call me,
you have
email me, and it's not a bother to do that. And I recommend that to anybody who has a personal injury case. If you want to know what's going on, reach out to your attorney. Find out what's going on. We've got so much technology nowadays. You can text your lawyer, email your lawyer, so we've tried to make it as easy as possible for our clients to, have an open line of communication with us, because I think you're absolutely right. In the pre-suit phase, before any lawsuit's been filed, when the client is treating, that's generally where you may not have as much contact. And that's because the client is going through that treatment process. And so that's when I think people are like, well, I haven't heard from my lawyer. But that's usually because you're going through the treatment. You're supposed to be really in touch with your doctors, and we're getting, the reports from the doctors. So. Right.
And our paralegals or legal assistants will be in contact with the clients probably more regularly than the attorneys themselves.
Exactly.
But the paralegal or the legal assistant is not the attorney.
Yes.
And so, although
the buck stops here.
Yeah, that's right. So I always say that one of my legal assistants is smarter than me. I won't let you know which one I say that about. I'll keep them guessing. But they do know a lot. But ultimately, if the client wants to talk to the attorney, we may just repeat what the legal assistant told them.
Right.
But at least we're there, and the attorney should always be available within reason to answer the questions that the clients have.
Right. And Matt and I have really only worked as attorneys at one firm. But so we can speak for our firm. You can meet with your attorney here. Yes. And you should be able to meet with your attorney and request an in-person meeting. Because a lot of times I think people get confused about whether that's possible, but you absolutely can come in, talk to your lawyer, request a meeting if you haven't met them in the beginning, which we try to always meet with our clients in the initial intake. But if you haven't, let's say it was done virtually, since COVID, that happens, more frequently than we probably would like. Call later and say, hey, I didn't get to meet you in person. Do you mind if I come by and meet you? Absolutely.
Sure.
Right. And I think you should always request that. It's good to have a face-to-face rapport with your attorney, right?
I agree 100%. I mean, it's client satisfaction.
Exactly. That's what we strive for at Perenich, Caulfield, Avril Noyes. We're going to go ahead and take a quick break and go to a commercial, and then we'll be back with some more questions about the personal injury process and what to expect.
All right. Thank you, Jackie.
Thank you, Matt.
Thanks. We'll be right back.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Perenich, Caulfield, Avril, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Perenich, Caulfield, Avril, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
And we are back with FLA Law live on the radio. We are still here in the studio for the rest of the 5 o'clock hour. Here answering your questions, legal questions live on the radio. We've had some great questions come in so far throughout the show. And if you are wanting to get your question answered, you still have time to call in to 727-441-3000. Again, we're also streaming live on Facebook and YouTube if you want to drop a question or a comment in the chat comment section. We can answer that question live on the air as well. My partner, Matthew Noyes, had to run off to his son Jacob's CCC baseball game. So we're hoping that they have a great game tonight against Largo and that they pull off a victory. And of course, you still have myself here in the studio to answer your questions. And we've been talking about some of the processes and procedures and things that you can really expect on a personal injury case. And a lot of times they're just frequently asked questions that people tend to have when they're coming into a personal injury matter, whether it be slip and fall, trip and fall, car accident, workers' comp, Social Security. We tend to hear a lot of the same questions asked frequently about the process and what to expect and how to kind of be satisfied as a client. And so Matthew and I were going over a lot of those so far. We had some great questions come in. But of course, if you have specific questions about any other area of law, like I said, the lines are open. You can certainly call in with those. But I'm going to jump back into some of the topics that we were talking about. And so at the end of the day, I know a lot of times we represent auto accident clients who find themselves in a situation where the other driver does not admit fault or they don't admit responsibility there's a dispute as to who caused the accident. Everyone is pointing the finger at the other, and someone has come to us and asked us to represent them and help them. And we see, based on the evidence or the photos or the statements, that the person that we are representing did not cause the accident, but the other driver also feels that way. And so a lot of times people are confused about, well, what happens if that other driver does not admit fault? And so a lot of times it turns into a case that will sometimes need to be litigated. And so what we always recommend is building as much evidence as you possibly can to prove your version of the facts, which is photographs. If there's any witnesses of people that might have seen the accident or were at the scene that were standing by, or they got out of their vehicle and came over to help or assist, get names, get phone numbers. If there's somebody that helped you, that maybe you slipped and fell and they helped you get up and they saw, what was on the floor, get their name, get their phone number. If there's someone that was working there and they said, oh my gosh, I told so-and-so to clean that up. Doesn't happen often, but if that's the case, you want to document that. What did they say? Who said it? Who were they talking to? Identify them, be able to describe what that person looks like. That way, if there's an issue in the future about who caused the accident or what caused the accident or dispute as to fault, you're able to have the evidence in place, and it helps the attorney who at our offices, we're skilled to be able to try to look for the things that we need to find evidence-wise that will help us prove that case when liability does become disputed. Now, unfortunately, in an auto scenario, if the fault is not admitted initially, you want to make sure you have collision coverage on your own policy, because if they don't admit fault in the beginning or there's no acceptance of liability, then there may be a huge issue getting your vehicle fixed and being able to get back on the road and driving. And if your car is disabled in a car accident and the other driver does not accept liability and they dispute fault, then you may not be able to get your vehicle fixed unless you have collision coverage. So I always tell people, protect yourself by getting collision coverage, having rental coverage, having uninsured motorist coverage. So that way, if you're in a situation where there's no coverage or liability dispute, you've got all the coverage that you need to protect yourselves, and you're not necessarily relying on someone else to have the coverage that you need to protect you, because people unfortunately are driving around the state of Florida without adequate coverage, sadly, and they're only required to have PIP or property damage in this state. And the PIP covers them when they're injured. It does not protect you. And the property damage limits, they only have to carry 10. So if your vehicle exceeds that value, you may be in a situation where you're, needing your own coverage to supplement what that other driver didn't have. So there can be a lot of problems created by the other driver not accepting fault or by there being a liability dispute. So it's always very important and key that you gather the evidence, take the pictures, call an attorney, and make sure that those things are being built up properly so that in the event that this has to be litigated or the case, taken to trial, that it's been properly handled in the outset. Because as you get further away in time from your accident, as months and weeks and years roll by, it's much harder to prove what the scene looked like on the day of the accident 2 or 3 years ago, or what the vehicles look like, or what direction did the cars travel, or on a slip and fall, what was on the floor, what was on your clothing, how did it look? All those things are quite important. And if you don't take the steps to kind of gather that information early on, it could hurt the case later. So consult with the attorney very early, gather as much evidence as you can to help yourself, because a lot of times that does happen where liability is not admitted or the defendant disputes, any type of fault or responsibility. And so a lot of times when that happens, people are thinking, well, if they dispute liability, does that mean we're going to have to try this case because they're not accepting fault? Not necessarily. So you do not necessarily have to go to trial simply because liability has been disputed. Sometimes that just means that we have to work a little harder to prove the case. We've got to look for videos. We got to look for witnesses. And it could be a situation where we've done our due diligence. We've found witnesses. We've found video that now resolves that dispute. The insurance company is now aware, and they're now ready and willing to reasonably negotiate, and the case can resolve without ever having to be litigated or tried. I know one of my partners, Brian Caulfield, often talks about a case where he was fortunate enough to find video of a disputed liability accident, very devastating. I think it was a motorcycle accident, and another lawyer had turned the case down, and he was lucky enough to find video at a business that was in the vicinity of the accident. And fortunately, he was able to get that video and was able to show exactly who caused the accident. And the fault actually did lie with the other party. And it resulted in a very substantial settlement for the family because they were able to prove what had initially been disputed by the insurance company. And so the answer to the question of, does the dispute mean we're going to go to trial? The answer is no. Most cases generally do not go to trial. A very small percentage of cases actually end up going to trial and going in front of a jury and making its way all the way to a verdict. And so the chances of that occurring are pretty slim, but it can happen. So I won't say that it won't happen. So if you find yourself involved in a car accident or some sort of liability dispute in a personal injury case, is it likely that the case will have to be tried because of that? No, but it is possible. And so like Matt said before when we were talking earlier, you always want to prepare the case from the outset as if it will go to trial. And so it's always important that you're gathering evidence, looking for videos, witnesses, photos, doing that in the very beginning in the event that it does end up having to go in front of a jury and be decided, for a verdict. So I know another question that we'd like to touch on in these last few minutes is about, whether I should hire an attorney at all. Matt and I talked about that, about whether it's needed, but a lot of people will sometimes ask, why can't I just represent myself? And I guess I could just get my own bills and present them to the insurance company and do my own demand, and then I don't have to pay any attorney's fees, right? Well, unfortunately, that's not necessarily how it works out, sadly. And I know it's become common knowledge now that people that don't have attorneys, they get less. They just don't get offered this same amount because they're not as informed. They're not experienced. They don't understand how to present the damages. They don't know what they're entitled to. And they're not necessarily presenting the entire claim in the way that it should be. They're not treating necessarily with the right providers. They're not getting the proper testing. They're not presenting all the bills and the liens and the things that they need to present so that they can be properly reimbursed. And so the best thing to do is to get your case into the hands of an experienced personal injury attorney who's able to say, these are the things you need. These are the things we have to present. These are the things that we need to fight for so that you can be properly compensated at the end of the day. And we have a question on Facebook that says, how does the attorney get paid in a case? So obviously, personal injury cases are somewhat unique in the sense that at our firm and at all, any type of personal injury law firm in the state of Florida that's taking on these cases, they're doing it in what's called a contingency fee basis. So that's not how all attorneys get paid. So family law matters, criminal law matters. Those kinds of cases are handled differently. We had a bankruptcy attorney on a couple weeks ago, and she talked about her fees, much different than what we do. So in a personal injury case, in this kind of accident where you're talking about a trip and fall or auto or some sort of injury claim, the attorney is actually getting paid in the end a percentage of the settlement that's obtained. So there's no retainer fee or hourly costs that it has to be paid up front. So a lot of times with personal injury cases, with like other matters, criminal cases, you may have to pay a retainer to that lawyer for them to get started to be able to do the work on the file. But in a personal injury case, there's no retainer, there's no hourly. You're not being charged every time you call the attorney or send them an email, and every time they read it, they're logging that in on a bill or an invoice. That's not the way personal injury matters work. So the way it works is if the case can resolve before a lawsuit is filed and before a defendant answers the complaint, it's 33 1/3% is the fee that is charged from the overall settlement, the gross settlement. If a lawsuit is filed and the defendant or the insurance carrier's attorney answers the complaint, then the fees then increase to 40%. And it's 40% of the overall gross settlement. And that's how the attorney is paid out of the settlement that's obtained. And so I know there's commercials, billboards, and things of that nature that are out there. And people are like, "Oh, it's free if you don't get anything, it's free." Well, that's essentially true in the sense that it's not free, but the attorney does not charge the client for any work that was done or investigations that were paid for or things that had to be done in order to try to properly evaluate that case. If it turns out that there's no coverage or the defendant is judgment proof, or for whatever reason the claim could not be pursued, then the attorney essentially does not get paid in a personal injury matter, and they won't be able to send you a bill. And the contracts pretty much set forth the fact that there's no upfront fees and there's no upfront costs. There's nothing that we ask our potential, new clients to pay out of their pocket. There's no deposits or retainers. But if we are able to make a recovery for you, whether it be 3 months down the line, 6 months down the line, a year, whenever the case resolves, at that point, those are when the percentages or the fees apply. And they can vary from case to case. Like we've talked about Social Security, we talked about workers' comp. Those fees are set forth differently, but they are still contingency. So with Social Security fees, we're taking a percentage out of the back pay that was secured on your behalf, but there's nothing that you pay up front. So that fee is paid directly to the attorneys from the Social Security Administration. If we obtain a favorable decision, the Social Security Administration pays us the percentage, and the client doesn't even have to sign anything. They pay that to us directly. There's no disbursement or anything into the case. And we just ask that our costs are paid by the client for Social Security. Same thing with workers' comp. There's no fee up front. There's no one that has to, pay us to get started. We do all that on a contingency basis. The contingency is us getting you some sort of resolution at the end of the case. So if it's a situation where it's a hit and run or, someone has caused an accident, they ran you off the road, or they, took off from the scene and you couldn't find them. We're never able to locate them. And although you were sadly severely injured, we couldn't find the defendant, or we find them and, as fate would have it, they have no coverage. There's no insurance. They don't have any assets or anything that's worth pursuing them or trying to get a judgment because they're judgment proof. They don't own anything. They don't have anything. And so therefore you being able to actually collect against them would be, fruitless. You probably would not obtain anything. In that situation, if you have hired us and we end up getting to a point where there's no recovery that could be made on your behalf, you won't get a bill from the personal injury attorney. You won't get a bill from us. You won't get an invoice for our time or our expenses, and sadly, because there was no recovery in that situation. But the good thing about it is we're very crafty and clever, and we're always able to look for those things that people aren't able to see and find the coverages and to find the people and the right entities to go after. So if you find yourself in that situation and you need a lawyer, call us at 727-796-8282. You can find us at voiceoftheinjured.com. That is our show tonight, folks. As you know, this is FLA Law live on the radio, and we are here every Tuesday night at 5 o'clock. We look forward to seeing seeing you again next week. We'll have our Halloween show with attorney April Goodwin talking about animal law. Next show is Tuesday, 5 o'clock. We'll see you then. Good night.
WTAN, Clearwater.
FM 106.1.
WDCF, Dade City.
FM 102.3.
Listen.
This is CBS News on the Hour.